got Aditya Thackeray there. He says the rebels have only two options, either face disqualification or merge with the BJP, MNS or Prahar party. But as far as disqualification is concerned, big development in the top court. The court has said that the deadline for the rebel MLAs to respond to the deputy speaker has been extended till July 11th, which is also the next date for the hearing. It's a massive relief for the Shinde camp. Let's first quickly go across to Nilashish. This definitely comes as a massive relief for the Shinde camp, but also a setback, at least in this first round that has happened in the top court.
A big setback for the Uddhav faction and a massive relief for the Shinde faction here coming in from the Supreme Court. Undoubtedly, this was the relief that they had sought when they approached court. An interim relief is the only relief that you can get on day one of a hearing unless your petition is dismissed. So in this situation, it gives them a lot more relaxation. It gives them a lot more time to, in fact, file their response. Also, the court has said that the life and property of all these rebel MLAs who had moved court must be protected as well. Now, as far as these MLAs are concerned, they have 2 more weeks time to respond to the disqualification notice. Till then, no action will be taken. So in a way, the stay of the rebel MLAs in Guwahati also extended by a stretch of the imagination, but definite relief, and this could be monumental and instrumental in terms of the of Maharashtra politics moving forward in the coming days, with the Supreme Court agreeing to keep at abeyance any sort of proceedings in the Legislative Assembly for 2 weeks.
Right, absolutely. Now, on the issue of threat to property and family, the court has asked the state to provide security, to provide immediate protection to the rebel MLAs. Let's also quickly take reactions from our guests. Abha Singh, in the observation, one of the observations, the judges also spoke about the ultimate jurisdiction of the speaker, which in this particular specific case is in question.
Jurisdiction to what extent? That his appointment, what was the issue? That these MLAs went away, the speaker issued a notice of disqualifying them. Shinde camp moved to Supreme Court and they said, no, we have moved a motion saying that the deputy speaker should remove because we are already 2/3 away. So now, if by giving 5 days, we cannot take it as a victory for Shinde camp, but yes, we can say they've got a reprieve, they've got a relief, and both sides would now put their points in a systematic manner. But the issue here is that can these MLAs, without joining a party, because anti-defection law makes it very clear, only on merger will they protect themselves from disqualification. So they may have got 5 days, but the anti-defection law still weighs heavily on their heads.
Okay, Mr. Kothari, how do you respond to that? Is it okay to say, safe enough to say that the court found merits in the arguments given by the Shinde camp? Because according to the Shinde camp, they want the deputy speaker first to prove whether he enjoys support, majority or not. And according to them, this disqualification process initiated in itself is illegal.
Is exactly what the court found merits in. Otherwise, the court would not have given time for another 2 weeks and stayed the proceedings. The court appreciated the fact that the petitioners came to them. They ventilated their grievances. The surround circumstances were also very pertinent. The court may not have mentioned that. The court naturally, if it comes to a conclusion that 2 weeks need to be granted to all the parties, it needs to keep the status quo. And by status quo means that you stay the proceedings that are ongoing. Now, as far as the anti-defection law is concerned, it is not necessary, as per paragraph 4 of the 10th schedule of the Constitution as amended by the 91st Amendment, for a party to merge. There is a word or there, that you have a chance to merge with the majority party or any party that you want to merge with, or alternatively form a separate faction. So that is a very important point. It is important. It's for the Shinde camp to decide what they wish to do. But that's a separate issue. That is something to come to only when the floor test comes into the picture. As of now, it is extremely important that the court did not agree with Mr. Abhishek Manu Singhvi's arguments. First is that why leapfrog? Well, Article 32 says that you can leapfrog to the Supreme Court straight for ventilation of your or for protection of your fundamental rights. Point number 2 is that you have come to the Supreme Court and now you are saying that the first point is that you should have gone to the High Court. We do not agree with that. 2 is that we have a limited power of scrutiny. What do you mean by the limited power of scrutiny? You are quoting Kyoto Holland versus Zachulu's judgment of 1992 to us. Yes, we agree we passed the judgment, and in that we said that the powers are limited. But limited only when the appointment of the speaker is legitimate. In that sense, yes, the speaker has the powers, and once it decides, only then when we can come into the picture. But here the appointment of the speaker itself is in question because the two-thirds rebel MLAs went away from the main Shiv Sena, and the main Shiv Sena, as per the numbers, whether they have the power to appoint somebody of their own. So there again the question of bias creeps in. So there are 2 points here, two main prongs. That first is you did not have the requisite numbers.
Right.
Two is you have appointed one of your own. Now, can you be a judge in your own cause? Can you say that your notice is not relevant to me for my appointment itself? So I can say, oh, no.
Right, Mr. Kothari, you're making some very important points, but I also want to go across to Harish, our legal editor, who has in fact been updating us about every single development that has taken place in the top court. Harish, please sum up the arguments, the takeaways as far as today's biggest development is concerned, and this definitely come as a massive relief to the Shinde camp.
Yes, that's right, Swati. The biggest takeaway is that it's a huge relief for all the 38 MLAs of the Shinde camp, as the Supreme Court has in a very significant order kept in abeyance the disciplinary action, the disqualification proceedings initiated against them by the Deputy Speaker as per the notice issued on June 25th. So now the order is that notices has been issued to the Deputy Speaker, Secretary, State Legislative Assembly, State of Maharashtra, Ajay Chaudhary, the Sena Legislative Party Head, and Chief Whip Sunil Prabhu. They have been asked to file their responses in 5 days to the petition filed by the Shinde camp MLAs challenging the disqualification process, and rejoinder has been sought from 3 days thereafter, and the next date of hearing is July 11th. So till then, the Deputy Speaker has been asked not to take any action against the MLAs. A very, very significant development as far as the Shinde camp MLAs are concerned. This is the precise reason they had in fact moved the Supreme Court, and during the hearing there were very significant observations from the Supreme Court as regards the competence of the Deputy Speaker in initiating the proceedings. The Supreme Court repeatedly asked, can the Deputy Speaker be a judge in his own cause? That means that, remember, this remarks came after the Shinde camp MLAs argued through Advocate Neeraj Kishan called that the Deputy Speaker had in fact rejected the no confidence motion notice against him filed by the Shinde camp MLAs, and so there were many other and there were several other precedents being cited in the Supreme Court like Kyoto Holohan cases regarding the power and expanse and the duties of Deputy Speaker and how he should hold the proceedings in the House. There was vehemently argued by Shinde camp MLAs that the Deputy Speaker, against whom a no-confidence motion has been initiated, himself he is not competent to issue notices of disqualification against the MLAs. They also question how the Deputy Speaker can give them only 48 hours time to reply to the notice or disqualification notice, and the rules say that at least 7 days time should be given to them for filing the reply to the disqualification notice. They also contended that after the government has reduced to a minority, the position of the Deputy Speaker goes. So therefore he has no power, he has no authority to issue such a disqualification notice. So after hearing extensive arguments, the Supreme Court has said that further arguments will be heard on July 11th when the matter will be taken up next. By that time, all these authorities have been asked to file the replies within 5 days, and after 3 days thereafter, the rejoinders have to be filed, and the matter has been kept for July 11th. But the biggest takeaway, as I earlier said, is that the dissident MLAs get 14 more days time to file replies to the disqualification disqualification notice. Remember, what is significant is that the deadline was ending at 5:30 today.
Right.
So the Supreme Court has extended the time from today 5:30 to July 11th 5:30. Back to you.
So 2 more weeks time has been given to the rebel MLAs to respond to that particular notice, and I believe on the 11th of July is when the next hearing also takes place. By that time, the speaker and the state also have to give explanation to the notices that have been issued to them by the court.
Yes, that's right. The Maharashtra government, the Chief Whip, Sunil Prabhu, and the Deputy Speaker, and the Chief Whip of Shiv Sena, and all of them, and also this leader of this Shiv Sena legislative party, all of them have to file the response to the petition filed by the Shinde faction challenging the disqualification notice issued by the Deputy Speaker. And one more biggest takeaway is that the Supreme Court has directed the government, also recorded the assurance given by Rahul Chitnis, the Council for State Government, that the life and property of all these different MLAs, all 39 of them, and the family shall stand protected. This came after the Shinde MLAs, camp MLAs submitted before the Supreme Court that they face the threat to their life, not only their families and the properties, and also told the Supreme Court regarding a statement made by one of the leaders of Shiv Sena that nobody will come back alive from Guwahati, 40 bodies will come from there. So Supreme Court took very serious note of this such arguments and said that the life and property of all these MLAs, not only their life but also their families and their properties shall stand protected.